in the name of the greatest people that have ever trod this earth, I draw the line in the dust and toss the gauntlet before the feet of tyranny, and I say segregation now, segregation tomorrow, and segregation forever.
Alabama Governor George Wallace declared at his inauguration that racial segregation would always be the law of the land in Alabama. Governor Wallace famously stood in a doorway to personally, physically block integration at the University of Alabama. He said it was a matter of conscience. He said God had put his state in that crisis, and God-fearing Southerners should grasp their destiny and lead the nation forward into a segregated future. Listen for the way he invokes the divine here.
We invite the Negro citizens of Alabama to work with us from his separate racial station, as we will work with him to develop, to grow in individual freedom and enrichment. This is the basic heritage of my religion, of which I make full practice, for we are all the handiwork of God.
Governor Wallace said that day, quote, "Southerners have played such a most magnificent part in erecting this great, divinely inspired system of freedom. And as God is our witness, Southerners will save it." Well, George Wallace was by no means the last racist to stand in a doorway to try to preserve racial segregation. That clip you just saw there from that inauguration, that was George Wallace in 1963. In 1964, it was the owner of a South Carolina barbecue chain who stood in the door of his restaurants. They were called Piggy Park restaurants. He stood in the door of the Piggy Park so that African Americans could not eat there. Maurice Bessinger didn't just think that segregation was a good thing. He thought segregation was biblical. He came from the school of slavery even as a divine right for white people and a not so bad situation for black people. And the civil rights movement and the end to legal racial segregation never changed his mind about that. In this century, into the 2000s, he was still distributing pamphlets at his Piggy Park restaurants with titles like A Biblical View of Slavery. While you waited for your ribs and your coleslaw, you could read about those many African slaves who blessed the Lord for allowing them to be enslaved and sent to America. This neo-Confederate titan of pulled pork told the New York Times that black people ate better than his other customers because their segregated dining room was actually in the kitchen. So maybe the food was hotter when it got to them or something. Maurice Bessinger still did hold those views about God ordaining slavery and segregation as recently as the year 2000, and when he wrote a book about it in 2001. This is the cover of his autobiography, complete with a giant stars and bars. He held these beliefs into the 21st century, but in the 21st century, he could no longer enforce these beliefs at his family business. In the 1960s, Maurice Bessinger had taken his case for divinely inspired racial segregation. He took his case to federal court. He argued that the Civil Rights Act contravenes the will of God. He had to be allowed to ban black people from dining rooms in his restaurants because he believed that God compelled that. And the U.S. Supreme Court heard that argument from Maurice Bessinger of the Piggy Park barbecue empire in South Carolina, and the United States Supreme Court ruled 8-0 that he actually had no right to discriminate just because he said God told him to. The court looked at the right of the barbecue guy to hold his religious views, and they looked at the right of Americans to move freely in society, and they ruled for the right of other Americans to not be impeded by his religious views, however sincerely he held them. They ruled 8-0, 1968. It was unanimous. Almost 2 decades later, the federal court got another case, this one from California. The founders of an evangelical private school believed, they really, really believed, that men are divinely appointed to be the head of the household. And as a school and as an employer, they based their HR practices on that belief. In the 1970s, they started off paying male staffers more than female staffers because men were supposed to support their families and women were whatever. But after they realized that was probably illegal, they decided instead what they would do is they would offer health benefits only to husbands or to single people. So if you were unmarried, you could get health insurance with your job there. If you were a married man, you could get health insurance with your job there. But if you were a married woman, no, your husband's supposed to take care of that. And so at that evangelical school in California, a wife grudgingly could be allowed to bring home a little bacon, but definitely no insurance. God says. In 1986, the federal courts looked at that religiously inspired discrimination, and they said, no, you cannot deny people health benefits, even if you say God told you to. The court looked at the right of the school to deny women health coverage and the right of women to get the same benefits as men, and they ruled for equality. At the Piggy Park restaurants, the same kind of religious inspiration to discriminate turned out not to be a legal justification to discriminate. So 1968 with integration, 1986 with work benefits, and now we have 2014. We have a very, very different decision in 2014. Today, the U.S. Supreme Court ruled that your boss can refuse to cover your birth control if that is what your boss thinks God would like to have happen. The 5 members of the conservative majority voted that the religious beliefs, or lack thereof, of a company's employees, those are effectively overruled by the religious beliefs of the boss. The boss's religion determines what laws apply to his or her employees and his or her business, at least on this issue. The court today said it made no judgment as to whether or not the religious beliefs against contraception in this case were beliefs that were reasonable or scientifically accurate. The court said their only job was to figure out if those beliefs were sincerely held. That's enough. You know, Maurice Bessinger, he's dead now, but even dead, he might still find this confusing because his belief in slavery and segregation as divinely ordained, that was certainly sincerely held, lifelong. Certainly it was based in religion. But in his case, that was not enough to deprive other people of the protections and rights that they were afforded under law. Now, though, the court today said apparently religion is all you need. The Reverend Dr. Welton Gaddy is the president of the Interfaith Alliance. And the Interfaith Alliance filed a brief in this case. Reverend Gaddy, when this ruling came down from the Supreme Court today, released this rather blistering statement. The Supreme Court made a grave error today. The balance between religious freedom and other compelling interests has always been tenuous, but we may very well remember today's decision as the moment that balance was radically recalibrated. The First Amendment is at its best when it is used to protect the rights of minorities from the whims of the powerful. Today's decision, which gives the powerful the right to force their religious beliefs on those around them, today's decision is a far cry from the best traditions of religious freedom. Joining us now is the Reverend Dr. Welton Gaddy. He's president of the Interfaith Alliance. Reverend Gaddy also serves as the pastor for preaching and worship at Northminster Baptist Church in Monroe, Louisiana. And full disclosure, he's also my friend. Welton, it's nice to see you. Thank you very much for being here.
Hey, Rachel. Glad to see you.
You too. Why do you consider today's ruling to be such a grave error? I was struck by the starkness of the terms in which you put your response today.
Because it is a grave error. I know that the words about it that you've used tonight are that it's a very narrow opinion, that it focuses just on these medications related to abortion. But, Rachel, this case, this decision left unanswered so many questions, and the court basically said to corporations, come on to us and file your complaints disguised as religious convictions, and we'll tell you whether you qualify or not. That is a dangerous way to go. We don't know what a close ownership is in a corporation. We know that the Wall Street Journal and Slate says it could be as many as 90% of the organizations in this land. Think about that. And the promise that this wasn't going to heighten discrimination that could be hidden under religion is simply not true. Do you want the Supreme Court of the United States deciding what is a sincere religious belief? That in itself is scary. So we don't know where this is going. It's very easy to see how this ruling, though it is narrowly about contraception, can be taken in courtrooms all across this nation and applied to all kinds of other discriminatory behavior that has the disguise of religion. And the court has invited that. That scares me. I think it's a bad decision.
Well, one of the things I thought was very interesting about the court asserting that this only applies to contraception is that the Justice Alito, writing in the majority, explains some other things that wouldn't apply. He's talked about Jehovah's Witnesses and opposition to blood transfusions, or I believe he mentioned another religious group with a potential objection to vaccinations.
Yes.
Are the justices, in effect, putting themselves in the position of saying, these religious beliefs about contraception or abortion, these are reasonable religious beliefs. But these other ones about the blood transfusions or the vaccines, we don't take those as seriously, and therefore we're sort of affording state protection to some beliefs, to some religions, but not others?
I actually tend to go more with what Justice Ginsburg wrote than I do what Justice Alito wrote. I think that they protest too much, and that's why I am worried that what they are painting as a very narrow little stretch of authority is going to expand exponentially. And Rachel, a part of the reason that people are confused about this is because we've seen a campaign for at least 5 years, maybe 10 years, in which people are trying to change the very definition of religious freedom. Many of the people you saw today cheering for religious freedom are the people we've engaged over the last 5 or 10 years opposing religious freedom. So if you're losing when you're opposing, you just change the definition and then start cheering for it. And I think that is a lot of what's happening today. The free exercise of religion in this nation is a guarantee of the Constitution. But that free exercise of religion for one person stops when that person's free exercise compromises the freedom of another person. And so here we're saying, because there's a close-knit family that believes this, that their belief's sincere enough, we can go with it. Now, anybody else that has that kind of sincere belief, we'll consider letting you do the same thing. That's not the role of the Supreme Court, and it is, I think, an offense to what the Constitution promises us in the religion clauses to the Constitution.
Reverend Welton Gaddy is president of the Interfaith Alliance. He's pastor for preaching and worship at the Northminster Baptist Church in Monroe, Louisiana. Welton, thank you very much for being with us. It's good to see you, my friend. Thank you. All right, lots ahead tonight. Stay with us.